Hello guys, welcome. Am I audible?
Yes.
Yeah.
So good evening everyone. I'm Ruchita Shinde, Senior Editor at Unique Law, and I welcome everyone present here to the webinar on the Personal Data Protection Bill 2019. We hope that you all are safe and healthy in this difficult time. So before moving on, I would like to mention one thing that certificates will be provided to all the participants and everyone who fills the Google form sent by us. And also, you will have to stay till the end. We will also have a Q&A session at the end. So I request all of you to keep your mic off during the session. If you have any doubts or any questions, put them in the chat box down below, which will be addressed later. So before introducing our guest speaker today, I'd like to tell you something about the Unique Law Journal. So Unique Law was founded in 2020 by Anirvan Chaudhary, an alumni of SLS Pune, Symbiosis Law School, and now has grown into a wonderful team where we aim to impact the students and help them develop their skills while they're still studying in the law school. So main focus of the today's webinar is to give information on the data privacy laws and all the changes which are taking place today. And also students can publish their writings or their research paper in Unique Law so that they get hands-on experience in researching writing at an early stage, which always helps because it proves to be an experience for them. This skills also prepare them for their future endeavors. The perks of your paper getting published in Unique Law is that first of all, it is free of cost. And also we have a proper functioning editorial board and mentors who are ready to help you at any moment possible. Also, we are entering into the realm of online courses where we will provide you extra information on contracts, drafting, and all those other interesting webinars and crash courses. So now I'd like to introduce our guest speaker today, Mr. Rohit Hebale. With
Hello.
passion for anything, hello sir. So with passion for anything related to data, technology, and intellectual property, Mr. Rohit Hebale is an advocate practicing IP litigation and a student of the renowned NLSIU's postgraduate diploma in cyber law and cyber forensics. He's presently examining the intersection between intellectual property law and information technology law in his thesis. In addition to being an ex-associate at Anand & Anand in the IP litigation team, he has also worked on compliance checklists, DPIAs, LIAs, and implementation of general data protection regulation during his various internships. So Mr. Hebale, during this webinar, will provide a general overview of India's Personal Data Protection Bill 2019 and analyze certain important provisions. So we'll definitely get a lot of knowledge today. And I would like to hand over the session to Sir, and let's start.
Thank you, Ruchita. If I may just share my screen right now. Okay, perfect. Is it visible for everyone? Okay. As you can see right now, it's a simple crash course on Personal Data Protection Bill 2019. I'd like to state at the onset that it's not exhaustive, but it more so deals with some of the important aspects that any layman or a student or an advocate should be aware about. Now, the first question that arises is, why is it relevant to you and I? Well, data is now the new oil, but the fundamental difference is that oil is finite while data is infinite. Therefore, the possibilities of being able to exploit either in a positive way or a negative way is endless. It is by nature an extension of ourselves at this point. Data is being produced everywhere with petabytes of knowledge being transmitted, produced, processed on a regular basis. Therefore, it's imperative that they are not only regulated, but the users are also empowered to understand and move forward with their own data. Treat it as an extension of their self, which it already is. So delving deep into the introduction right now, what is the concept of data protection? Because it's a fundamental thing that you need to understand before you delve deeper into the bill. Now, in this case, the concept of data protection is quite simple. The idea behind it is such that it needs to protect privacy. There needs to be a regulation of flow and usage of personal data, because if there is no regulation, not only can the people who are processing and collecting and using your data be able to do with it whatever they would like, but you are also left in the dark as regards to what your rights are related to it. Furthermore, data is now the new frontier, which means that countries themselves who possess technological companies that have huge stores of data can potentially change the way the world is going to look in the next 10, 20 years. Therefore, in so many ways, this is the revolution that is required, the information technology revolution. Therefore, there needs to be a proper, transparent flow of this data, and it needs to be regulated in accordance with accepted norms and regulations. It also needs to build a relationship of trust, because right now you are unable to truly trust your service providers, other entities, social media intermediaries, and so on and so forth. The reason being, you have no idea what it is that they do with your data. It is very likely that if you were to provide your phone number to someone in Pantaloons, you might get a call from H&M, because you have no clue where it is that they're going to draw the line with what they'd like to do with your data. Cold calling, robocalling, getting a lot of spam messages. We're all kind of used to it at this point. It's become such a huge problem that most of our inboxes and most of the calls we get on a regular basis are the calls and emails that we do not want. Thus, it needs to build a relationship of trust where we're aware of what it is that these entities are doing with it, what rights we have available to exercise whenever we would like to, and where it is that we would like to draw the line. Next, the concept of data protection is about safeguarding user interests. Now, as a user myself, I understand that I have certain interests, which includes that my data not be shared wherever it is not altered, it is not corrupted, it is not sold to the highest bidder. So one of the examples that I can give is every time there is a credit card fraud that you hear online, wherein thousands and millions of credit card information is either on the dark web, or you find that Facebook accounts and Twitter accounts and passwords and other personally identifiable information is also on the dark web given to the highest bidder. Now, this creates a fundamental challenge because it is starkly against the principles of justice, equity, and privacy. We not only need to be empowered enough to realize our interests, which in all fairness is not unrealistic. It is very simple for us to want the personal data aspect of us to be protected just as our body is, because as I've stated previously, it is just an extension of ourselves at this point. Therefore, there needs to be good framework that is in place that we can utilize either for grievance redressal, either for personal data breach reporting, either for appealing any sort of decisions that might not go in our favor. It is either to ensure that there are certain obligations on the entities that are processing our data, controlling our data, and more than anything else, also on the state itself, because the state at the end of the day ends up being one of the biggest consumers of our data, be it non-personal data, personal data, and so on. It is of huge benefit to them to ensure that they have a sort of a semi-monopoly over what happens with the data of their citizens. Similarly, there needs to be established acceptable standards that remains common across the board, not only just within a huge country like India, wherein different states might have different requirements, but also across the world, wherein there is interoperability, wherein different countries can speak to one another and speak the same language, follow the same practices, understand the same standards. By doing so, not only are you bridging the gap between the digital economy and the countries that are not part of the digital economy yet, we are creating a very inclusive digital culture wherein everyone understands what their rights are, what their interests are, and how to go about exercising. So, why is there a need for a data protection legislation? I've already stated what the concept is behind it, but now it's all about the redistribution of control. Prior to this, you had no way to prevent an entity to process your data however way they wished. Now you're taking control of what is truly yours, and you are now able to not only do with it what you please, but you're also able to limit whatever alteration that might take place without your knowledge, your supervision, without your permission. And by doing so, by having a legislation in place, the quality of the data that is being collected improves greatly. Because right now, the example that I can give is that the data that you might have posted 10 years ago about you wanting to sell a house is absolutely obsolete. You no longer need to sell a house because you've already sold a house, but in the process, you have given your personally identifiable information. And if someone were to call you right now and say they're interested in buying your house, not only have they wasted your time, they've wasted your time as well. And the internet again becomes this cauldron of fake news, misinformation, and low quality data that is being shared again and again online. To prevent this, to put a stop to this, and to ensure that there is a certain standard with regards to how data is actually being present on the internet, this legislation is truly helpful. The improvement of technical infrastructure needs to go hand in hand with this legislation, because without it, there is no way we can implement some of the rigorous requirements of this legislation, either at the state level or at a private entity level. It's fundamentally required that they are able to trace the source of the data, who they've shared it with, how it is that they can delete it, and so on and so forth. So this, again, just as it improves the quality of data, also improves the technical infrastructure available for everyone, so that we can move forward and ensure that there is accountability and transparency. As I've already stated earlier, you would like to know what happens with your data, and the entities that process it are bound to tell you what it is that they do with it and how it is that they do it. They need to give you an estimate and understanding of what processes they have in place to mitigate risk, how it is that they report any breaches to the authority, what kinds of data that they need from you, and why is it that they need it, and when they're going to stop using it. It is your absolute right to be aware of all of this, and at the same time, it is their duty to ensure that you are informed. Similarly, you also have grievance redressal mechanisms. This is the only way for us to remove anything that we believe is outdated, incorrect, no longer accurate off the internet, or if we believe it's been processed without our permission, without our consent. Consent, as you know, is king. And now, especially in the personal data protection regime of today's world, there needs to be consent for every small little thing unless it is impracticable. In grievance redressal, for example, you will need to show that the entity either had consent when they processed it, or they relied on other grounds of processing, which I'll be covering shortly. It also erases ambiguity and arbitrariness. Now, this is absolutely key, because ambiguity leads to um, a lot of harm for those who have not drafted the legislation. It also puts a lot of burden on the judiciary and other quasi-judicial bodies to have to interpret everything. And because in doing so, it increases the time frame for any sort of redressal. And arbitrariness, as we all know, is extremely harmful for a free and fair democracy. The state is very easily capable of infringing on your rights, even though they should not, and at the same time abusing the loopholes in the legislation to their own benefits. Thus, in this process, we end up exploring a new dimension, a dimension wherein we are now bridging the gap between what we think is perceived distance between our corporeal body and the personal data that we believe is removed from us. But as I've already said before, it is simply an extension. It is absolutely a part of us. It is part of our identity. And in today's world, without our data, we are nobody. We are ghosts. And especially in the coronavirus pandemic, without existing on the internet, our footprint would absolutely vanish. So it would have grave ramifications for those who are not able to understand, utilize, and prevent any sort of action that might not benefit them, or that might not be okay with them. Now, there are already a couple of foreign legislations out there that specifically deal with personal data protection. The EU in 2016 was a trailblazer when it came out with the General Data Protection Regulation. It got rid of a whole list of other data protection legislations that were already in place in its EU constituent countries, and made a uniform, up-to-date legislation that was also implemented in the UK's Data Protection Act of 2018, wherein they strengthened data subject rights or user rights. They heightened the duties and obligations for data controllers and processors, also other entities. They also ensured that there is a proper mechanism for you to be able to address your grievances, appeal the same, and ensure that there is a proper penalty system whenever offenses are created. And it ensured that companies were no longer let off with just a slap on their hand if they were abusing the way they were using data. It ensured that there were huge penalties, up to 4% of their total worldwide revenue, which for a company, let's say like Facebook, would amount to billions of dollars, to ensure that they wouldn't abuse personal data. California also recently in 2018 came up with the California Consumer Protection Act, where it changes the way it views a user and more so looks at it from the perspective of a household, wherein an address containing multiple users is bundled up into one. And Singapore also has a relatively updated Personal Data Protection Act. Australia right now is in the midst of updating their Privacy Act, which was passed in 1988, to ensure that it comes up to date and up to speed with the requirements of today's day and age and the way data is being processed today. Now, having looked at those, we understand that there are some key elements that every single data protection legislation needs to have to make it robust, to ensure that the people who it's meant to benefit can actually derive benefit out of it. So as I've already stated, there needs to be obligations on processing entities. There needs to be specific set grounds for which they are processing, the actual purposes behind it, and why it is that it is a justified purpose. Because mind you, any sort of violation or infringement of a right, a fundamental right especially, needs to be justifiable, proportionate, and necessary. Because of that, they need to give proper clarity on the same. It needs to have proper user rights, wherein we can exercise all possible avenues to ensure that there is no harm done to us. There needs to be an emphasis on consent, because consent right now is by far the most overarching ground for processing that they can and should rely upon, because you are informed, you are willing to them to process your data. Grievance redressal mechanisms. Then data breach mitigation frameworks are the sort of acts and tasks that and that an entity can take once they become aware that there is a personal data breach. How do you mitigate the risks out of it? Facebook, for example, when it found out that thousands and millions of its users' details were were hacked and sold on the dark web, it contacted those who were impacted and told them to change their password. They ensured that there was double-factor authentication. They ensured that they did a legitimate interest assessment. They did an impact assessment to try to figure out how it is that they can prevent it from next time around. There also needs to be technical and organizational implementation. Now, any implementation of a data protection legislation has to be twofold. One, as you know, is the technical infrastructure aspect of it, where you have proper systems in place, mechanisms, consent frameworks, managers, so on and so forth, plugins, for example. But at the same time, it's also at the organizational level, wherein you need to train your employees, you need to train the officers to ensure that they understand what are the accepted practices, what they need to do with the data that they have with them, and how it is that they can prevent any sort of a difficult situation when it comes to your personal data. Again, you require a specialized adjudicating authority because courts are already overburdened and they are not specialized and educated enough to be able to truly go to the nuances of what it means to deal with information technology, network security, indexing, how search engines works, and so on and so forth. So you need specialized individuals who are trained not only in technical aspects, but also in law with experience to be able to decide properly how it is that any dispute arising in this area to be adjudicated upon. And obviously there needs to be appropriate penalties specifically developed for the offenses arising out of it. Previously, India had bundled everything under the Information Technology Act. There were also certain rules and guidelines that were given for security procedures that intermediaries can take, but neither were these regulations truly implemented. But the IT Act itself could not fully account for all the nuances that data protection legislations have to bring about. So there needs to be specific penalties for specific offenses. And now, when it comes to India, specifically the Personal Data Protection Bill, you need to understand a little bit of a procedural history of how we got here. In 2017 and in 2018, there were two Puttaswamy judgments, the first of which was a 9 constitutional judge bench, which basically enshrined the fact that the right to privacy was a fundamental right. That was the first step. But that in itself is not enough for us to exercise our rights, because in the 2018 judgment, they directed the government to ensure that there was a robust data protection legislation in place for us to do so. Therefore, there was a committee instituted, a 10-member committee, which was called the Justice Sri Krishna Committee, which gave out a report in 2018. In addition to that, they also produced a bill, the draft Personal Data Protection Bill in 2018. However, it went through a lot of changes with regards to the stakeholders. A lot of stakeholders were consulted, Mozilla, many law firms also gave their comments, such as Ikigai and other governments, and they also looked at foreign legislations to see how they could improve upon the same. One of the key aspects of this stakeholder consultation process that helped us was that the concept of data localization was watered down. What that means is, prior to this, the bill mandated that all sensitive data, all critically sensitive data, all forms of important personally identifiable information was stored in India, which would put a huge burden on not only all Indian companies operating here, given the financial investment that would be required, but also foreign companies who would look twice to see if they would even want to process the data of Indian citizens. So this consultation process really helped. And in 2019, of the December of 2019, the updated present Personal Data Protection Bill was produced in the Parliament. However, it was immediately referred to a 30-member Joint Committee of Parliament. And up to this point, the said Joint Committee, the lead, Ms. MP Meenakshi Lekhi, has asked for 4 different extensions on this particular report. So presently, the way it's going, it is supposed to be tabled for discussion and possibly passed during the monsoon session of the Parliament, but it has been delayed multiple times, so we're unsure as of now. So now that we've completed, sort of a good background about what data protection is, how it is that our bill came to be, we can go slightly deeper into what the statement of objects and reasons are, what's the aim behind this bill, how the applicability works, and so on and so forth. The idea behind this bill is quite simple. It's meant to protect privacy relating to personal data, build up a trust-based relationship between the users and data processors and controllers and all other entities that deal with your data, ensure that there is a specification with regards to how it is that data flows exist, what the transfer would look like if it is moving from one country to the other, ensure that there is a protection of rights of the individuals, especially given the fact that personal data is a critical means of communication between persons. And the bill needs to foster a collective culture to ensure empowerment, inclusion, progress, and innovation through digital governance. As regards applicability, they have primarily divided it based on whether the entity that is processing is geographically present in India, or if the entities are governed by Indian law or arising out of Indian law, or they are also ensuring that there is an extraterritorial aspect of it, where the FX doctrine is being applied to see if any foreign entity does any sort of business or systematic activity that offers goods, services to any users living in India, or profiling them to understand their behavior, to see if advertisements can be directed to them, to see if they would be open to the idea of buying a particular product in the future, then it is they're ensuring that since the effect of this particular service or good is being felt in India, the same is going to be applied as well, even if it is a foreign country, foreign entity. But to truly understand this legislation, we need to keep in mind that there are certain definitions that we would like to understand before we move forward. The first definition, and this is important, is that it's what anonymization actually is. Anonymization is an irreversible conversion of your personally identifiable information to remove all identifiable characteristics and standards, identifiable characteristics, and the standards of which are dictated by the Data Protection Authority itself. In doing so, what we do is we protect the data that is there, remove any identifiable information, and ensure that it is no longer personally identifiable. Therefore, our interest, vested interests in the same is no longer that of personal data. When you look at de-identification on the other hand, you will see that it is not an irreversible process, but a reversible process for which no standards are set, but it just masks any of these personally identifiable information using fictitious values. And while it helps in preventing the direct identification of a user, it can be reversed, and it is doable, wherein you will be able to figure out certain key identification factors that will help you identify an individual. As regards a data fiduciary is basically a data controller or an entity who, in conjunction with others, determines the purpose and means of processing this personal data. And this is the entity that you truly have a relationship with whom you control the nature of this relationship and the nature of the processing. Now, a fiduciary contracts a processor, and a data processor is someone who actually processes this personal data on behalf of a data fiduciary. And what is this personal data in the first place? Like, how does the bill define it? Basically says that it's any data pertaining to any natural person who is directly or indirectly identifiable. Now, this can include any online or offline data. It can include a combination of these data sets. It can include inferences as well, or you are using one data set in conjunction with another to identify a particular person. The degree of identification has not been made clear, but that is the general idea behind it. And the actual operation of processing itself includes either a set of operations or just one operation, which is performed on data, and it includes collection, alteration, restriction, deletion, and so on and so forth. You can basically think of it as a blanket term to say that something is being done with your data. The second it leaves you and it leaves you and someone else has it, it has been processed. And then it goes through multiple different stages and levels and types of processing after that. And profiling is a sort of a type of processing itself, wherein an entity analyzes your behavior and interests to advertise goods or services to you. But there is an element of analytics required in it. The way I can give you an example is that if you were to go to a website, now the website becomes the data fiduciary. And if that website uses Google Analytics to cull out relevant information that they can use to later on target services or goods to you, then Google Analytics becomes the processor. You have a direct relationship with the fiduciary, and the fiduciary has a contract with the processor to decide the nature of the processing. So therefore, it's important that you're aware of all these different moving parts. And sensitive personal data is data that has a slightly higher threshold with regards to how fiduciaries have to treat it. It includes financial information such as your credit card information or your bank account statements. It includes health information such as if there is a history of obesity or sugar or diabetes in your family. It includes genetic information, whether you fall under a particular category of people. It includes caste information, gender information, sexuality, so on and so forth. Basically, any sort of data with which there can be harm or significant harm on the data principle. Because based on this, either you get credit loans or you're rejected, you are allowed admission into a college or not, you are treated unfairly by a particular state agency or not, based on your sexuality or your gender. You also might be discounted from employment opportunities on this particular sensitive personal data. So it's important that we understand this before we move forward. Now, we have already talked about what the obligations of data fiduciaries look like. But if we delve a little bit deeper, you will see that there are certain key core principles that they need to keep in mind when they are processing personal data. When they're processing personal data, it needs to be processed in a manner wherein it is specific, clear, and lawful. That the fiduciary, the entity basically, that is the controlling entity, needs to be specific regards to how it is that they're going, how, why, and what it is that they're going to be processing. They're clear in their messaging and they're not ambiguous in nature. And it also needs to be for a lawful purpose. Any unlawful purposes automatically fail under an obligation. It also needs to be fair, reasonable, and for the consented purpose. Whenever consent is involved, the data subject has communicated to the data fiduciary that he only consents to a particular processing, particular kind of processing, for example, the collection of the data, but you do not consent to the sharing of that same data. In this case, then the processing needs to be either incidental or connected or under the same circumstances under which consent was given in the first place. Now, the principle of purpose limitation and data minimization is also a key obligation, as it is imperative that data fiduciaries ensure that they only process data that is under the purpose that is absolutely necessary for this particular purpose, so that you are not using multiple data sets for varied purposes when in reality you could have done so with just 10% of the data that you've collected. And you also need to minimize the quantum of data that you're taking. If you only need someone's date of birth, address, and a name, there is no requirement for you to also take their phone number, email address, and financial information. While you as an entity would greatly benefit from it, there is an imbalance with regards to the relationship between us, the data subjects, and the entities themselves. Which is why data in terms of quantum of collection needs to be minimized. And every single time, whenever a clear notice that contains a lot of information that includes different categories of data that they're processing, purposes for processing, grounds for processing, what rights we have, how is it that we can exercise these rights, what is the redressal mechanism, what is the fees for the same, and this needs to be given in a clear, concise, comprehensible manner, and potentially in multiple languages. If you are if you're unaware of how it works, it needs to be given in the most simple language possible, so that the average data subject the layman needs to be able to understand what are his rights and so on and so forth. And finally, it also needs to be accurate, updated, and complete. As we already discussed, the quality of data is fundamental. And because it is so, it needs to be accurate, because inaccurate data can lead to a lot of harm to a data subject. It also prevents the data fiduciaries themselves from truly targeting advertisements or goods or services to you without correct and complete data, which is why we need to ensure that it is also updated and accurate. In addition to these, we also need to ensure that there is the entities, the data fiduciaries also need to ensure that there is storage limitation. And what storage limitation means that if data can be stored for a span of 3 months, and that is the absolute minimum time that is necessary for them to truly process it. There is no requirement for them to store it any longer than that. So they are bound to delete. They are required to delete data that is absolutely not required for their processing. So there is a certain set period for which they can hold on to the data, and then they're forced to process it. So by doing so, they are being responsible and accountable. Responsible not only to the state to which they have to fulfill certain obligations, but also to data subjects for which they are accountable. They, by being accountable, they are ensuring that there is a privacy by design in their technical and organizational framework. And what I mean by privacy by design is quite simple. You bake it into your organization and technical framework. Privacy comes first at all times. There is a review process wherein you ask certain key questions. Is this data absolutely necessary? Are we collecting under the right purposes? Are we fulfilling the grounds? Do we need consent specifically for this? What categories of data is this falling under? When you look at every single operation and activity from the perspective of the privacy of a data subject, you ensure that the privacy by design is baked into your system, and you no longer have to worry about it many ways down the line when there might be a personal data breach and so on and so forth. By doing this, they're also remaining transparent. And whenever there is a transparency from the data fiduciary, data subjects are free and capable of realizing their rights under this particular legislation. Now, certain security frameworks, are absolutely required, such as how it is that they're going to use de-identification procedures, how to prevent misuse or unauthorized access, and are they being continuously reviewed? These are all safety and security safeguards that are required and that need to remain updated again and again, so that there is mitigation of risk and so that the interests of data subjects are protected. Now, personal data protection breach reporting mechanisms also fall under the same principle, wherein you are bound to tell the authority, the data protection authority, that there has been a particular breach. And owing to this breach, how is it that you're handling it? What are the circumstances of the breach? What are the categories of personal data that were breached? And how is it that you're communicating the same to the data subjects? Because you owe duty to two different entities here, the state and the data subjects. Furthermore, by limiting entities that can process your data, by limiting it to just the data fiduciary with whom you have a contract, it is a written contract to ensure that you can always take it up in court, you can take it up with the authority, being the court itself in this case. But there is also a limitation on sub-processing. No data processor who has been contracted by your data fiduciary to process your data can allow another entity, another data processor to sub-process it, because there are certain standards that are required from both the processors and the fiduciaries. And if they do not meet those standards, what you're doing is you're jeopardizing the personal data of all your data subjects in the process, which is why unless and until the contract that you have with the data fiduciary specifically states that sub-processing is allowed, only then will sub-processing be allowed. So you are basically aware of all the entities who are processing your data. Similarly, the mechanism that we've already discussed under Section 32 stipulates that within 30 days, your data fiduciary should address your grievances. If you are not happy with the way the data fiduciary has addressed your grievances on having paid a small fee and having communicated your grievance to them in writing, then you can take it up with the authority. Now, as we were talking about earlier, consent is the broadest ground for processing, and grounds for processing can include many things, reasonable purpose, for employment, for health, for state function, which we'll talk about in the next slide. But consent is by far the strongest ground for processing. The reason being that once you consent to something, the the extent to which they can process is far greater than if they were to process under any other particular ground. And for you to be able to give actual consent, it needs to be free, it needs to be informed, specific, clear, and capable of withdrawal. And by free, I mean it's without coercion, there is no undue influence, there is no misrepresentation, no fraud, no mistake. And informed means that you've properly been informed under the notice requirements under Section 7. It's specific because you, the data subject, can determine the scope and extent of the consent for processing and what data it is that they're actually processing. It needs to be clear, as in it needs to be affirmative. No longer are companies and data fiduciaries allowed to have those boxes that are already checked, uh, opting you in automatically. No, it needs to be affirmative, wherein you need to, out of your own volition, opt into any of the communication that you're getting or opt into any sort of a processing. This ensures that it's meaningful and it's contextualized and it is exactly what it is that you want. And with regards to capable of withdrawal, all of us are aware as to how easy it is to sign up for marketing newsletters. But we also know how difficult it is to sign out of them because you are expected with one click, you can with one click sign up for those. But for you to sign out, you need to specifically address an email to a particular email that they might have provided. It might be a very small difference, but it's a sort of a behavioral tick that they use, that they are aware that data subjects would not go so far as to spend energy and effort and time signing out. So it needs to be proportionate. If it's easy to sign up, it needs to be equally easy to sign up. And with regards to the fact that no service, good or right, can be conditional on unnecessary consent. Now, this is important because if consent is not absolutely necessary for any particular good, service, or right, then they cannot state that if you do not consent to this, we will ensure that you do not receive the same. That is a sort of a bargaining tool that they've used till now to force the hand of many data subjects to provide consent, which they then use to process data on a wider scale. We need to ensure that this does not happen, and the bill specifically states to that effect. And to prove consent is not on us. The burden of proof is solely on the data fiduciary, which is why it is also in their best interest to have a proper consent framework that they can use to communicate to any individual or entity for that matter that that they have actual consent. In addition to that, there's also a legal consequence of withdrawal of consent that has to be borne by the data principal itself. Now, that's problematic because if there is no valid reason for us to withdraw consent, then we are the ones who are going to be having to bear the burden of the same. Now, there are certain exemptions as well for this, and these exemptions include functions of the state for giving any service or benefit, such as Aadhaar or a certification, like your driver's license, wherein consent is not required, medical reasons like medical treatment, if there is a particular law in effect or judicial orders, then in compliance with those, for disaster management, or to ensure that there is no breakdown of public order, or for employment reasons wherein your employer might require your personal information to ensure that you are onboarded in that particular entity. Additionally, there are also reasonable purposes that is a very blanket sort of statement that is used that includes mergers and acquisitions, information security, whistleblowing, and unlawful activity prevention, operation of search engines, and so on and so forth. While this is not extremely clear, it does provide additional exemptions for entities to process your data without consent. While we've discussed consent, there are certain other exemptions from other obligations that the data fiduciaries can utilize, specifically to ensure that they don't have to follow through with some of the requirements. They don't have to have their obligation to not notice, to not provide notice, their obligation to not have proper consent frameworks, to have proper grievance redressal mechanism. And certain exemptions include, the power that the governments themselves to have to exempt other government agencies from the same, which is extremely problematic because they can basically ensure that the bill is implemented, but only is applicable for everybody but the government in India, for other judicial functions, for prosecution of offenses, or for a claim or legal right, or journalistic purposes. Journalistic purposes are slightly more justified given there needs to be good quality of information. There are also research, archiving, and statistical purposes. You can also limit these obligations by having contractual arrangements with foreign entities, or contractual arrangements with an Indian entity processing foreign data subjects. There's also an exemption for manual processing by small entities because the data protection bill mostly and only talks about automated means of processing, wherein an information technology means is involved. And with regards to an innovation sandbox, wherein if a data fiduciary has privacy by design implemented, then many of these obligations can be relaxed a little bit to ensure that there is innovation with regards to artificial intelligence, with regards to intellectual property, and so on and so forth, so that there is a general improvement in quality of those related fields. Now we've looked at obligations of data fiduciaries. We are going to quickly look at the rights of data principals, which we've already talked about previously as well. You have, as a data subject or a data principal, the right of confirmation and access, where you can confirm if data is being processed or not. In addition to that, you can also also access information, provide summaries with regards to different kinds of processed data. You also have the right to accurate data, as we've already talked about, and right to erase data that is no longer accurate. You also have the right to portability, which is wherein your data is shared to another data fiduciary in a commonly used, structured, and machine-readable format, and is generated as a part of your profile. And right to be forgotten is quite similar to right to erasure. The only difference is that it restricts the continuing disclosure of personal data in certain situations. Unfortunately, the Indian bill does not have the right to object or right against automated decision making or profiling specifically, though that right is kind of codified a little bit through sensitive personal data. Now, having looked at the rights, we move on to just the Data Protection Authority. Now, the Data Protection Authority was established in such a manner so that it adjudicates upon all disputes arising from it. And its composition includes one chairperson with up to 6 members, one of whom must at least be educated in law. They come for 5-year terms and up to an age bracket of 65 years, and they're only for single terms, and they must be trained in IT such as privacy, cyberspace, so on and so forth. Their powers and duties include the ability to classify certain personal data as sensitive personal data, classify certain data fiduciaries as significant data fiduciaries. They can also appoint adjudicating and inquiry officers. They can prevent misuse, raise awareness, ensure compliance and examination reports, and so on and so forth. And if you're unhappy with the judgment of the Data Protection Authority, you can appeal to the Appellate Tribunal and the Supreme Court, so on thereafter. Now, it has created a tiered penalty system, the Data Protection Bill, wherein contravention of certain provisions, such as not registering with the DPA or not conducting a data protection impact assessment, would cost you 5 crores or 2% of your total worldwide turnover, whichever is higher. Or if you violated something worse, such as violation of obligations or ground for processing, violation of data subject rights, or you don't have security safeguards in place, then it can go up to as much as 4% of your total worldwide turnover, or 15 crores, whichever is higher. So there are certain other offenses and penalties as well, which you can see on the screen. but they are supposed to ensure compliance and supposed to ensure that it acts as a deterrent. Yeah, it also these offenses are cognizable and non-bailable, and only the Data Protection Authority itself can institute a suit against you. Uh, and they are not afraid as well of moving against companies or the state by piercing the corporate veil and holding the relevant person accountable. In the process, if you feel there has been significant harm impacted to you, you are also free to ask for compensation. Now, the way forward. Now, this is the most important part, because how do we ensure that this bill, when it becomes an act, by the time it becomes, at least is improved? How is it that, like, what are the issues? What are the places that can be amended? And that is very important, because no bill should remain stagnant. No bill should be produced, or act should be produced in isolation. And no bill should have a particular agenda set in mind that does not benefit the people it is supposed to benefit. So some of the key areas where this bill requires improvement is: one, there needs to be proper, acceptable standards of anonymization. What, even though anonymization is irreversible, it is difficult because it is totally based on what the acceptable standards of anonymization are at that point. Standards can increase, at which point anonymization comes to the level of de-identification, where it becomes reversible. So there needs to be acceptance over that. There needs to be a proper mechanism for withdrawal of consent, and especially that the consequence should not be on the data subject or the principal if we were to withdraw our consent. Some of the clauses are unclear with regards to construction. For example, data minimization and purpose limitation are not specifically stated, but we opine from it. So they need to clarify some of the language there, and some of the exemptions for state agencies suffer from overbreadth. They, under reasonable purposes, can pretty much process whatever data they want. They also have the capability to ensure that the data protection bill itself is not applicable to any state agency itself. So that's quite problematic. Then there is also, from the looks of it, we need to ensure that there is no dilution of the need for consent. It needs to be granular and specific, and should not be circumvented through reasonable purposes and so on. Presently, the bill also does not specify any sort of timelines, and it falls on the Data Protection Authority to specify them, and especially with regards to how long a data fiduciary or a processor will have to become compliant with the act. And obviously, we're all aware that there are present limitations with technical infrastructure that will make it very difficult, especially for smaller entities, to implement this. So we need to keep that in mind and give them additional leeway to do the same. Additionally, you will also have slight difficulty in balancing different stakeholder interests, because you're supposed to balance both the obligations and the interests of the data fiduciary itself with that of the data principals. And that's quite a fine balance to maintain, and not every single time would you be able to maintain that balance. And again, there are no set agreements on the standards, which needs to be a multi-stakeholder discussion between different governments, different companies, smaller processing entities, the data subjects themselves, other controllers, and so on. And sandbox as well. As we talked about, some of the obligations are relaxed when it comes to data fiduciaries that want to be part of the sandbox, but they're quite ambiguous, and they need to specifically give more guidelines on how it is that they're still going to guarantee data subject rights. And then one of the most problematic is that there's a huge burden on the Data Protection Authority. One, because there isn't a lot of independence, because the people who are going to be appointed as a part of the authority is specifically from the central government. It's going to it's a long time consuming and protracted process for them to make regulations, certified code of practices. They also need to keep in mind that India is too big and too varied for a single DPA to exist, and we might require state level DPAs as well to ensure that there is nuanced decision making and legislative construction. There is also, the bill also stipulates that there has to be forced sharing of non-personal data, which is a discussion from another time. But basically, non-personal data presently is any data that is not personal in nature, such as aggregated data, anonymized data, so on and so forth. And again, anonymization and de-identification limitations still remain, wherein it is totally based on the technical infrastructure, the acceptable standards. So we need to keep that in mind as well. Now, the lessons that we can learn from the West is that we need to put the data subject, the data principle, front and center of these legislations. It's very difficult because the governments themselves and the state themselves have a lot of vested interest in it. So it's quite difficult to do so. So we can definitely learn from GDPR. We can learn from the UK's Data Protection Act, because they're very strong and they are meant to last quite a bit of time. We also need to keep in mind the technological, financial, and human rights considerations of the same. It's going to take a lot of time. It's going to take a lot of financial resources. Not every company or entity is going to be compliant, but we still need to keep moving forward without being disheartened in the process. The final thing is that we need to ensure that there is, the government, especially the state, needs to ensure that there is legitimacy, proportionality, and necessity whenever it is that they violate this fundamental right to privacy, which has already been enshrined. So in line with the same, any company could make certain preparatory, could have certain preparatory actions that they can take, wherein they decide what, whether they are a data fiduciary or not, whether they're a data processor, review their activities continuously, have a proper consent framework, understand what the grounds of processing are, review your methods, apply a data protection officer, and so on and so forth. But they need to do it in line with the act, but at the same time ensure that there is a balance between the rights of the data principles and the requirements that the government is imposing on. Lastly, what is the new frontier? What is it that the bill does not really talk about? As of now, it truly does not yet clarify the interfacing with the non-personal data, which is very important given the fact that that is the heads to the tails, that is personal data protection. And they also the bill also try to bungle online intermediary guidelines as well, which in my opinion, and people are free to disagree, requires a set of own regulations and legislation that are separate from this. All in all, thank you. If you have any questions, do let us know. But yeah, that's about it.
Thank you, sir, for this enriching session. We don't have any question, which just means that you explained it very, very well.
Thank you.
So, guys, fill the feedback form and over to Ramya.
Good evening, all. On behalf of Uniqlo, I take this opportunity to thank all those who directly or indirectly contributed in this webinar. First of all, I would like to thank our guest speaker, Rohit sir, for taking out time for this webinar. And sir, thanks for enlightening us with your knowledge and presence. Today's session was really very informative, sir. Further, I would like to thank Anirban for his enthusiastic support and the entire editorial board of Uniqlo for their unflinching support and coordination. And at last, I thank each and every participant present here for making this webinar a successful event. Thanks again, one and all, and thank you, sir.
Thank you.